This is LXBN TV, and I'm Colin O'Keefe. This week, the Supreme Court heard oral arguments in Christopher v. SmithKline Beecham Corp, a prominent case deciding whether pharmaceutical sales reps are exempt from overtime. To explain the case, we bring in Joshua Alley, attorney with Proskaur and author on their blog, Proskaur on Class and Collective Actions. First off, what is the background here? Who are the players that are involved?
Sure. There are actually three significant players here in this case. The first is GlaxoSmithKline, as they do business as. This is a large pharmaceutical company. They represent. They employ thousands of pharmaceutical sales representatives nationwide to go out and promote and sell their product to healthcare practitioners. And so those pharmaceutical sales representatives have brought suit. Over the last several years, they've brought suit against most of the major pharmaceutical companies, alleging that they are misclassified as exempt from overtime under federal law, the Fair Labor Standards Act. So those are the two main players in how this suit got here. But there's also a third player in the mix, which is the United States Department of Labor, who has weighed in on this private litigation by submitting amicus briefs in both this case and in a previous case that was before the Second Circuit involving Novartis. And the Department of Labor has sided with the pharmaceutical sales reps that they are misclassified and are entitled to overtime. So those are the three major players that we've got going on here. And all three of them were represented by sort of the titans of the Supreme Court on Monday at the oral argument.
Very interesting. This is a case that's gotten a lot of discussion. We've seen many posts on it come across publications on the Lex Blog Network. So why, in your mind, is this case so important? What's at stake here? Obviously, it goes beyond, just this case.
Sure. I think this case has implications both within the pharmaceutical industry, outside the pharmaceutical industry, and also just as a general matter of regulatory interpretation and deference. To defer, how much deference should be given to the Department of Labor and when they interpret their own regulations. So clearly, from the perspective of GlaxoSmithKline, this is a hundreds of millions of dollar issue. They employ over the years thousands of sales representatives who work significant hours. I think most of them. They work outside of the office, and so it's often difficult or impossible to track how many hours, but they're also very well paid. This industry employs, at least by some estimates, close to 90,000 sales reps at any given time throughout the pharmaceutical industry. The average earnings is anywhere from $50,000 to over $100,000 a year. And so if it turns out that these sales reps are entitled to overtime based on such a high starting base salary, we're talking billions of dollars for the industry. So that's what's at stake for GlaxoSmithKline and what's at stake for the industry. For companies that beyond the pharmaceutical industry, there are many other industries and companies that employ what they call outside sales representatives, and there may be a question of whether those individuals are truly selling goods or services within the meaning of the law. And so there's implications. There's implications there for those other companies, and then we've got this regulatory question, which I think the Supreme Court was particularly interested in, which is how much deference do we need to give to the Department of Labor, where they are purporting to interpret their own regulations. These regulations have been in effect for 75 years with little or no enforcement and no guidance, at least in regards to the pharmaceutical industry. And the DOL weighed in an amicus brief, not by doing any sort of rulemaking and formal notice and comment period, but by submitting an amicus brief originally before the Second Circuit, and also in this case before the Ninth Circuit. And the Ninth Circuit case is what eventually got up to the Supreme Court. And the reason is that both the District Court in California and the Ninth Circuit refused to defer to the Department of Labor's interpretation. They rejected the Department of Labor's view and held that that a common sense and practical approach led them to conclude that these pharmaceutical sales reps are really operating like a true outside salesperson.
Mm-hmm. I see. And then finally, you had a great piece covering this, but, what are your thoughts on this week's oral arguments? What stood out to you?
Well, I think the thing that stood out most to me was at least three of the justices expressed extreme. I think it went beyond skepticism. They were visibly taken aback by what the Department of Labor has done. In their view, the DOL has sort of sat on their hands for close to 75 years. It's been well established, and it's been common throughout the industry that these pharmaceutical sales reps are classified as exempt from overtime, and no one's ever done anything about it. Mm-hmm. Certainly not the Department of Labor. There have been no enforcement actions. There were no legal opinion letters or guidance, and there had been no private litigation either. And then all of a sudden, approximately 4 years ago, we started seeing a wave of class action lawsuits, collective action lawsuits being brought against pretty much every pharmaceutical company, and they were focusing primarily on this outside sales exemption. Mm-hmm. And it's an interesting question because the reps are not actually selling drugs; they're not allowed to sell drugs, and so whether they fit within the meaning of whether they're making sales within the meaning of the law is sort of an open issue. And Justices Breyer, Kennedy, and Scalia seemed particularly taken aback that the Department of Labor was taking the position they did, that they'd done it in the way they did through an amicus brief, and that they had not gone through the sort of formal rulemaking that one would expect when making a fairly large policy decision, because they weren't just deciding. Certainly, they were deciding in this case that, in their view, pharmaceutical sales reps had been misclassified. Well, that's $1 billion retroactive liability. But on top of that, they were also deciding that this is how we're going to interpret our regulations in a particularly stringent way. And certainly, from the defense standpoint and from the standpoint of the respondents in this case, that interpretation is at odds with how the DOL has gone about applying the outside sales exemption over the years. So it's certainly, I was a little surprised at how much the Deputy Solicitor General was attacked from the bench. I think the brunt of their questioning and skepticism was certainly focused on the DOL, because the issues for the petitioner and the respondent, whether pharmaceutical sales reps are, quote, making sales, whether what they're doing is more akin to promotion work or sales work. I mean, those are very interesting questions and ultimately go to the merits of the case. But the justices, I think, appropriately recognized that was a thorny issue, and because there had been so little guidance over the years, I don't think they were prepared to jump in and make that determination. They would prefer to rely on the DOL, and they weren't happy with what the DOL had done here.
It's going to be very interesting to watch. This is a huge case, and like you said, there's a lot of money at play, and depending on the outcome, it's going to be interesting to watch and see what impact that has afterwards. Once again, that was Joshua Alloy of Proskaur and their blog, Proskaur, on class and collective actions. For more on this story, again, Josh has a great post breaking down the oral arguments even more in depth. Be sure to check that out. It's at classactions.proskaur.com. And, of course, we have a number of posts on the case at lxbn.lexblog.com. Just go there, run a search, click on the tag, and you'll be able to see all of them. Thanks for your time on this, Josh. I thought it was great.
Thank you so much. You as well. Thanks.